And welcome to the webinar, The Business Case for Becoming a Second Chance Employer. I am Mike Coffey, President of Imperative Information Group. And again, for those of you who are just joining, for whatever reason, Zoom will not recognize my camera all of a sudden. So you don't get to see me, but as long as you see the slides and can hear my voice, we're in good shape. This presentation is one of my favorites. It's really important to me as an HR person, as the owner of a background investigations company, and also as just a member of our society, that we make sure that employers are fairly and legally evaluating individuals' qualifications for employment, even in the context of having some past criminal history or other blemish on their on their history. And I'll just reiterate that nobody is just their criminal history. I say that a lot in a lot of my presentations, except for maybe Ted Bundy. Ted Bundy is just his criminal history, but for most people, past critical errors in judgment and criminal behavior isn't always, is not normally the only thing that we need to know about that person when we're evaluating them for employment. So I appreciate you joining us today. This is the first in a series of webinars about using criminal history and making sure that as we screen our employees for various things that we are doing it legally, but also just beyond that, just fairly and in a way that benefits our companies and society. So let's get started. And first of all, drop down into the chat box and just let me know, do you consider your employer a second chance employer? I'd be curious to know if you think so. Definitely. Great. Michelle, Maria, yes. Anybody else? Lisa, thank you. So, not really. Okay. Sometimes depending on the offense. Okay, good. We'll talk about that a little bit today. Appreciate that. Thank you, Jean. Yes. Okay, super. Well, I think that's, and that's what I hear. I was at HR Southwest the past few days and talking about criminal history and other things. And a lot of employers said, yeah, we do it, but we're not always as maybe thorough or thoughtful, or we don't have a process in place to do that as effectively as we'd like to. And so that's what this series of webinars is really all about. And I hope that it'll be something that's really beneficial to employers as you go through this. So what are your concerns about becoming a second chance employer, or if you're already a second chance employer, what kind of considerations, what really worries you or gives you pause? Liability, okay, that's a good one. And that's one I hear a lot. What's our liability if we put the wrong person in the wrong seat and somebody's injured? Any other concerns out there you might have? That tends to be the single largest one. I'm not saying anything, but drop in the chat box if you see anything and I'll pay attention. Well, I will say that liability, employers are interested in candidates' past criminal history because certainly we want to protect our employees, the rest of their coworkers, from any undue risk. We want to protect our customers, both physically, financially. We want to protect their information. And we have a responsibility to the public to make sure that we're not creating risk in our communities by putting the wrong person in the wrong role. Certainly that would be, putting a driver behind the wheel of a motor vehicle or a truck or a larger vehicle like that in the public right of way, so that you don't have to, we just worry about drivers and all kinds of things like that. But anybody interacting with the public, we want to make sure that we know who we're setting out there and what that means. So first, let me just go through my standard disclaimer. There are many preferred terms out there to describe individuals with criminal history. And you see some of them there on the screen. And no matter which top term I use, I'm going to get it wrong. I'm going to offend somebody. I've just found that over the years, speaking about criminal history, there are all kinds of different sensibilities and sensitivities around there. I am going to use the term former offender. That's just the term of art that I use. I think it's a hopeful term. This is somebody who in the past has committed an offense, and I'm calling them a former offender. I'm assuming as we have this conversation that as we talk about these individuals, that they're not going to be committing future offenses. And of course, part of what we have to do is evaluate the risk that if we put this person in this role, what might their past behavior suggest about the risk that they present in that role. But I'm going to use the term former offenders, but you see some of the other terms we see pretty regularly. Returning citizen, touched by the justice system, are two of the euphemisms that probably mean the least to employers when they first hear it. But I'm seeing them, especially from advocates for second chance hiring and helping former offenders reintegrate into society. I hear those terms a lot. So when I'm talking about being a second chance employer, what I'm talking about is a way that an employer can make a fair hiring decision, a well-informed hiring decision, so they really understand. So you're not hiring in the dark. You're not hiring without knowledge of what somebody's past might include, but you're making that decision in a fair manner. So you've got a process in place where you can consistently and hopefully with limited bias, if not totally without bias, evaluate those individuals for the roles, and where we're doing it legally, because certainly you've got Title VII concerns we'll talk about, and then on a state-by-state basis, and even on a city-by-city basis, sometimes there are specific requirements that you have to pay attention to as an employer, considering an individual's criminal history in the employment context. So what are we talking about? You hear these numbers about people's criminal history, and you hear what does criminal history even mean? We hear all kinds of terms out there. Drop in your organization, when you're talking about someone's criminal history, drop in the chat box and let me know what criminal history means in your organization. Just jump right in there. And this is just weird for me to be doing a webinar without a camera on me. So I have the double disadvantage of not being able to see all of you folks. Plus, I'm not able to see you're not able to see me. Yeah, and Darian, just so you know, as everybody else puts their information in the system, those who arrived late, there's no camera on me because for whatever reason, as I prepared for my cameras worked all morning on Zoom. As soon as I turned on the webinar part of Zoom, it refuses to recognize my camera. So we're going camera free today. I washed my hair, brushed my teeth, and everything. So let's see what we said here. An individual with a felony arrest in your organization, Michelle, you said that. County criminal records, MVRs, even civil litigation, somebody said. And I'd say civil, that's a background check, but maybe your civil litigation is not really a criminal history. Beth, hi Beth, there's my friend Beth, convicted of a felony or misdemeanor. Craig Cadell, there's my buddy Craig, a conviction of a crime relevant to the job for which I'm hiring. Convictions beyond a Class C misdemeanor, RAWS, conviction of a felony. So yeah, convictions beyond traffic. So there's all kinds of topics out there, of definitions of criminal history. We hear the FBI's numbers thrown around a lot. When the FBI is talking about individuals with criminal history, they're actually talking about a specific subset of all the folks out there who've interacted with the criminal justice system. When the FBI is publishing numbers, and the numbers that they really, the data that they really collect are about individuals who were arrested for a felony offense, regardless of what the outcome of the case was. So the FBI, first of all, and if you've been on any of my other webinars, you know that there's no such thing as a nationwide criminal background check. There's no such thing as even any kind of reliable database that includes that information. The FBI's National Crime Information Center database is information coming from the states, and many of the states do not give the FBI everything. But when we hear the FBI talking about criminal records, and it's important because that's where we get this magical 70 million Americans number, they're talking about individuals with felony arrests. But there are a wide variety of definitions out there. And many of you just referenced only convictions, and we'll talk about that in this and other webinars. But convictions aren't, I would argue, the only thing employers are concerned about, and we'll talk about maybe why that's the case. Some employers use the term criminal history to refer to anyone against whom a criminal case is filed. So you get past the arrest, but a criminal case was actually filed by in a misdemeanor or felony court. Some employers ignore misdemeanors, and I would argue that that's a mistake as well. We'll talk about that at some point. But in our definition today, I'm going to talk about criminal history in the context of any time a criminal case has actually been filed. So there's a case number out there, and there's a record someplace in a courthouse of that individual's criminal history. So I mentioned the 70 million Americans number, and some of the reentry groups have published that number, saying that 70 million Americans have a criminal history, and in fact, they are all unemployable. No employer, you employers are all unfairly discriminating against them and refuse to hire them. In fact, there was a paper published by one of the National Employment Law Project, published a paper a number of years ago called 70 Million Need Not Apply. And that's kind of a ridiculous thing, because at that time, unemployment was very low, and it was clear that there were not 70 million people actively looking for work and unable to get it simply because they had a criminal history. I found that most employers are willing to hire people with criminal histories, even criminal histories that would make maybe some other employers blush or give them pause or concern before they hired somebody. But what we really need to realize is that this is your employment population. So how large is that population with an actual felony conviction? If 70 million people have been arrested for a felony offense, according to the information from the FBI, how many have actually had a conviction? Well, in 2010, the University of Georgia did a study and figured out that about, at that time, 7.3 million Americans, about 330 million, were serving time or had served time in prison for a felony. In the same study, that's about 3% of the population. The same study estimated that about 8% of the population, or about 19 million people, had an actual felony conviction, meaning they were actually found guilty. So we're not talking deferred adjudications, we're not talking about dismissals or other cases, other situations where the case didn't end in a conviction. So about 19 million people have felony convictions. But these are only felony convictions, right? So what about those deferred adjudications or cases that were outright dismissed for some reason? We know that about 58% of felony cases end in an outcome that doesn't require imprisonment. So just straight probation without going to prison, or a deferred adjudication of some sort. But as you'll hear, I do recommend that employers be as concerned with misdemeanors as they are felonies. In fact, the EEOC's guidance suggests that employers should be concerned with the conduct and less than what the classifications of the offense would be. So how many misdemeanors are out there? It's really difficult to figure that out, because I just have not seen anything that looks like a reliable number from any kind of government entity or any reliable study. But I took that 70 million number, or the 19 million number that from the University of Georgia study, and applied it against the data we have as a background screening company that does, has over the last 22 years done who knows how many background checks and delivered a ton of records on individuals. And so we know that roughly misdemeanor records outnumber felony records 3 to 1. So for every felony we report to a client, we see at least 3 misdemeanors. So if that's the case, that takes that 19 million number back up to 76 million Americans with some sort of felony case or misdemeanor case. And why am I spending so much time even talking about all of this? Well, primarily because unemployment in our country right now is relatively low, and the number of jobs is very high. And this is your applicant population. This is where you may have to turn to find your folks. According to a study published in 2018, looking back at older data from 2008, the unemployment rate was in 2008 for formerly incarcerated folks, and we're talking about felony offenders there, was 27%. And that was at a time in 2008 when unemployment was at 5.2%. So according to that study, formerly incarcerated people were 5 times more likely to be unemployed. Now, I will throw the big caveat in there that you don't hear in a lot of the studies that are published by folks who are really actively involved in helping former offenders reintegrate into society. The fact that former offenders are 5 times more likely to be unemployed does not necessarily mean that that is employers' fault, or that employers are unfairly mistreating individuals with criminal history. Because let's face it, many of these, especially former felony offenders, the fact that they committed the felony shows that at least once in their life, and often you can see patterns where it seems consistent, that these are people who make critical errors in judgment, and who are probably not, in many cases, compliant citizens. And none of us as employers are looking for opportunities to manage people at a higher level. And I don't know how interested all of those folks are in even looking for work and getting up and going to a 9 to 5 everyday drive. There are a lot of studies that correlate joblessness and recidivism, again, suggesting that the recidivism rate, or the frequency with which former offenders commit new offenses, is tied directly to their ability to find a job. Well, it's certainly true that, as I said, former offenders are 5 times more likely to be unemployed. However, to say that that's the employer's fault just makes a giant assumption. Correlation is not causation. And it seems just as likely to me that former offenders who have the mindset necessary to avoid criminal activity in the future are also those who look for and accept and maintain employment. I I don't think it's fair to lay it all at employers' feet. In fact, I would say that because there are so many success stories out there about former offenders who have found work, I would argue that, in fact, those who are unable to find work either, aren't looking very hard, or they've got behaviors that are on an ongoing basis preventing them from getting meaningful work. In other words, they're not staying out of trouble, or maybe they can't pass drug tests or things like that. So um, I think the biggest difference between those who successfully move past their criminal behavior and those who don't is their mindset. And as employers, I think that's one of the things we really need to be aware of and look for ways to identify in candidates with criminal histories to see how that mindset may even benefit us if somebody is moved through a bad point in their life where they make bad decisions and move beyond that. And here's the truth, right? I think everybody here said pretty much they are a second chance employer, with just maybe a couple exceptions. Most of us are already second chance employers. We're considering people with some sort of criminal history. And the reality is, you're a second chance employer, even if you think you're not a second chance employer. There are very likely, if you're a very large employer at all, people with criminal histories working for you that you're unaware of. And they're probably operating at a level that's if they're still with you, that's safe and efficient and profitable for your organization, because none of us are hiring people who aren't. So it's very likely that you're already, even if you don't see yourself as an active second chance employer, you probably already have employees with some sort of history. And most employers, just when I was at HR Southwest this past week, I asked the question, who's a second chance employer? And almost everybody raised their hands enthusiastically, recognizing that we're going to look at the factors, and we'll talk about some of those, that and try to be fair and do it legally, make sure we're not violating Title VII or any other laws. So a lot of employers are already there. I think it's just the reality of where we are today, that we need to expand our talent pool. Former offenders have a harder time finding work, and not everybody is right for every job, and certain criminal offenses would probably make you not as fit for certain roles. But when unemployment right now in the U.S. is a little over 5%, and open jobs are increasingly hard to fill because of all the issues with reopening and the changes in the workforce. I'm pretty convinced that we are, as employers, we have to be more thoughtful about how we evaluate criminal history, just in order to fill the open jobs. But that doesn't mean we need to be reckless. Another reason to become a second chance employer is that the percentage of voluntary quits, the likelihood that those employees will quit on you, for other employment, is lower. They're less, according to a study from Northwestern, individuals with criminal histories are less likely to job hop than the general population. And so think about what it costs in your organization to recruit, onboard, train, and manage a new employee. The studies suggest that that's really worth, 2.5% to 3% of somebody's career wages is just the cost of that initial onboarding. So if that's the case, and you can keep an employee in your employment for a longer period of time without replacing them, that'll save you money. And there's a variety of reasons that may be out there for this, and I haven't seen any studies that kind of definitively point to that. But I think the most obvious one is former offenders know that their past critical errors in judgment and this actions suggest to some employers that they're not a reliable risk. And so they're less likely to go looking for other opportunities. Likewise, they may well, because of their past experience, especially when they've been in a state or a federal prison system of some sort, they may be more grateful of what the opportunities an employer gives them, and less likely to go looking to see if the grass is greener someplace else. By the way, at the conclusion of the webinar, we will be emailing everybody the slides and notes, and every one of my slides are pretty much just pictures, as you see, but there's a whole page of notes for almost every slide, including citations to some of the reports and statistics that I reference. Another reason to have a good second chance employer process is that the former offenders have a lower involuntary termination rate than the general population for many positions. That same Northwestern study I mentioned earlier looked at a group of call center employees, and they were all in kind of a customer service role. And they found that those employees who had a criminal history were no less likely than the general population of employees who didn't have a criminal history to be terminated involuntarily. And so that's one of the things we're often worried about, right? Is that these, just because if somebody has a criminal history, they may take more management time, they may be less compliant. And in some cases, certainly those are considerations we want to pay attention to. But we may find that very often they are less likely to have involuntary terminations than the general population. And so in the customer service area, they were less likely to be involuntarily terminated, or were the same as those applicants with criminal history to be fired, basically. But interestingly, for sales positions, they were 34% more likely to be terminated for misconduct than those individuals without a criminal history. So that's interesting to me that we have people who, in a customer service role, they're no different than the rest of the population as far as likelihood of involuntary termination, even though they've got a criminal history. But people who go into sales were more likely to be terminated. So clearly there's something going on there. And as we all know, if you're in a role where you manage salespeople or you have salespeople in your organization, salespeople by nature, many of them, what makes them good salespeople is the fact that they're not compliant people, right? They're not rule followers. In fact, if they're about to go make a sales call and they walk up to the door and it says no soliciting, you would not want your salesperson just to say, oh, okay, and turn around and walk away. You would want them to be charming and talk their way in and make the sale, make the introduction to your company anyway. And so my thought around that is that it's possible that because we're already hiring for salespeople who are non-compliant, it may be that that's too much freedom and for some former offenders, and maybe we need to pay more attention in certain roles that by their nature don't require strict compliance, and maybe make sure if we're actively hiring former offenders for some of these roles, that we are prepared to pay attention to compliance issues and have better controls around some of those kinds of positions. Another reason to do it is it's plain old good public relations, right? One of my favorite books is Conscious Capitalism by John Mackey, and he's the co-founder of Whole Foods. And the idea behind the whole book is that as employers or as businesses, we have certainly responsibilities to our shareholders and our customers and our employees, but we have broader responsibilities also to the community, to regulators and government officials, things like that. And certainly a lot of what we call the millennials and zennials and the younger generations. Somebody pointed out very rudely, I thought, that the oldest at HR Southwest this week, the oldest cohort of millennials are now 41 years old. I still think about them as kids because they're still a lot younger than me, but that generation and the ones that have followed are very interested in knowing they're working for a company that's doing good in their community and is making a difference in their community. In fact, in my presentation at HR Southwest over business ethics, I talked about statistics that demonstrate that employees trust their employer more than just about any other institution, including the government and the media. But they also, with that trust comes a high level of expectation that those employers are going to actively be involved in social issues and make a difference in their communities. And so, being a second chance employer and being public about it, and being public in how you are fair, but also how you're protecting customers and making sure that you're doing it wisely, is a could be a good PR effort on your part as well. Then there are tax incentives out there for employers. I would argue that the tax incentives, the work opportunity tax credit for former offenders, is not a reason to actively hire, consider an individual employee applicant for a role, but it's certainly something to take advantage of. That work opportunity tax credit is worth up to $2,400 when you're hiring people who are qualified ex-felons, and that means they've been convicted of a felony and they were hired within release of being, or they were hired within a year of being released from a prison for that felony. So it's a very narrow window. They have to have been released within the previous year, but it's up to $2,400 for hiring that person in a role. So again, I wouldn't say that that's a reason to hire them, but that is a benefit that you can take advantage of. And then some state and local governments have incentives for doing that as well. Now, the thing about these incentives, and as I said, it's not a reason to select a specific employee, but it's just like bonding. There are bonding programs out there as well that help protect employers, but we need to evaluate the risk that a specific person suggests for a specific role when we're looking at a potential employee, not just the fact that there's a tax incentive or that we get some sort of insurance against the loss if they cause a loss of some sort. Another reason to consider former offenders is simply we want to avoid disparate impact claims. In 1975, the federal court in Green versus Missouri Pacific ruled that MOPAC violated Title VII of the Civil Rights Act when they had a policy that said we don't consider anybody with a criminal history. I go deeper into that in some of our other webinars, but the short version is that the Green case, Mr. Green was a Vietnam era war protester. He refused to register for the draft, among other things, and served some federal prison time because of that. After he had served his prison time, he applied at MOPAC, and MOPAC said, we have a policy. We don't hire people with criminal histories, regardless of what it is. And on its face, that policy seemed not to, target any protected class. It didn't have anything to do with age, race, sex, national origin, religion, those kinds of things. But the court found that because African Americans in the US are arrested, prosecuted, and convicted at a higher rate than the white population, this policy was creating a disparate impact on individuals in a protected class and MOPAC couldn't demonstrate a legitimate business reason for that policy. So really, without even having to get into the specifics of Mr. Green's violations of the law that put him in prison, the court was able to say, just on its face, this policy is going to create a disparate impact, and they're a disparate impact without a legitimate business reason, and is illegal, a violation of Title VII. In 2015, BMW agreed to pay $1.6 million to settle a lawsuit in which the EEOC claimed that BMW's exclusions of certain contractors' employees from employment created a disparate impact on minority employees as well. So it's still an ongoing issue. I will say that other than some settlements like the BMW case, no, since Green versus Missouri Pacific in 1975, no plaintiff suing an employer for violation of Title VII based on criminal history disparate impact has ever been successful in front of a judge or a jury. It's not to say there aren't employers who are creating an illegal disparate impact, but the reality is that these are cases that are based on statistics, and they're really hard statistics to prove. And the EEOC has not been successful, and the plaintiff's bar hasn't really been successful doing that, except in getting settlements. And what I'm thinking is it's very likely that companies like BMW and others who have faced these cases have settled them, both because the PR would be horrible, but also it would be very expensive to defend these lawsuits in federal court. So being a second chance employer, having a process where we fairly evaluate the risks somebody presents for a specific job as part of evaluating the entire applicant will help us avoid those kind of disparate impact claims. Oh, we jumped up to one. And then the bottom line is that if you have an objective risk-based review process, it's going to lead to quality hires. And just like we look at the entire applicant education, where they've worked before, what the scope and nature of their previous responsibilities were, all of those things, criminal history is just one part of that applicant. And we should definitely review it. We should definitely review it in context of what the risks associated with the job are and all of that, and be fair and objective about it. But when we review all of that, that will increase the quality of the hire that we make and hopefully give us better employees all the way around. But employers need a plan to do that. And that's the real trick, is how do we safely and legally hire former offenders? Just having a policy that says, hey, we're fair and we're going to we're going to consider everything on a case-by-case basis. I still hear that language a lot. I've even heard EEOC trainers use that language, saying, well, employers should consider somebody's criminal history on a case-by-case basis. Well, what does that even mean? And if you ask 20 employers, I think you get 20 different answers. Probably inside your organization, if you ask 20 managers, they're going to give you 20 different answers. And what I've seen way too often in organizations we've consulted with is that a case-by-case basis allows your hiring managers, or sometimes, heaven forbid, even your HR folks, to apply their own biases in making the decision as to whether criminal history is relevant or not. For instance, you see somebody with their third DWI, which in Texas would be a felony, 3 years ago. Let's just say, for the sake of argument, this position doesn't even require you to drive. Okay. But, oh, wow. Well, this applicant went to the same school I did, grew up in the same neighborhood. In fact, has the same color skin I have. I'm pretty comfortable that, yeah, he learned his lesson and he'll be a reliable employee. I don't have any issues with that. And he doesn't, in this case, he's not going to drive anyway, so it doesn't really matter. But then perhaps I get an applicant with that same DWI 5 years ago, but yeah, he didn't grow up in the same kind of life I grew up in. Maybe he's got a different phenotypic traits like skin color and things like that. Just a different it comes from a different social background than I do, and all of a sudden I'm nervous. My own biases are kicking in, and maybe I don't even realize it, but I'm treating this candidate with the exact same offense differently than I would somebody who is in my in-group. And in-group bias is a real thing. And I am convinced, I'm convinced that we still let too many of our hiring decisions be affected by it. And so, but if we have a process in place where before we ever meet our applicant, we know that this particular offense in this time period is high risk for this particular job, or medium risk for this other job, or even low risk for a third job. If we've built that process out, we've already done a lot of the analysis initially to say this is high, medium, or low risk for this role. Then that's going to make it easier for us to remain bias-free and objective in evaluating a candidate. So what does that look like? Well, a position-based risk assessment. So, we're not having to do the entire analysis on a case-by-case basis. And so I'm going to walk us through what that outcome might look like. I've got a whole hour-long webinar on just how to get to this point, but you can see here that for the sample position here, and let's just say this was for a car dealership, and we were hiring a salesperson for our car lot. And you can see we've got these three columns here with the color-coded columns. The first one is 0 to 3 years. The second one is 3 to 7 years. And the last one is 7+ years. So how long ago did the offense happen? Within the last 3 years, the last 7 years, or more than 7 years ago. And then you can see there's the H, M's, and L's. That means that position is considered high risk, medium risk, or low risk for this particular position. And again, this is well before we've ever met the applicant we're doing this. So let's look at the alcohol category of offenses: alcohol consumption or possession. And we're not talking about DWIs here. We're talking about open container on the streets, those kind of things, operating or drinking alcohol in a place where you're not allowed to have alcohol, those kinds of things. And even in the last 3 years, we're going to say for a car salesperson on our car lot, we're going to call that a low risk. In fact, who knows? Maybe you can't even hire a car salesman who doesn't have a drinking problem. But in our environment, we feel pretty comfortable with somebody with an open container and public kind of offense. We're going to call that low risk, even in the last 3 years. But we get down to the drug crimes, and we're going to say, well, if they've had in the last 3 years, or really in the last 7 years, if they've had a drug offense of some sort, we're going to call that medium risk. Certainly medium risk doesn't mean we're not going to hire them, but these folks are going to be in a car. They'll be driving a vehicle. They're going to be in a car alone with customers away from the dealership on test drives. We really want to understand what their drug offense was. We're going to call it medium risk. We're going to dig deeper into the offense history to understand what happened and just get a better idea of what happened before we make any kind of decision as to relevance of this offense to this particular applicant's fitness for this role. But then you look at the very top row there, auto theft. You know what? If you've been convicted or you've had a case for auto theft in the last 7 years, we're going to consider that high risk for our car dealership. And so we're going to call that a high risk offense. And so that's, and that makes sense. I'm not sure that I would want somebody convicted of auto theft necessarily working at my Cadillac dealership. However, that even a high risk offense doesn't mean we're going to automatically exclude them from employment. What it means is that's a high risk. Their past behavior correlates very highly to the job that we're considering them for, and it presents a lot of risk. So we're going to look at the entire applicant, evaluate that applicant against the rest of our applicant pool for risk, along with qualifications and sales, their experience with sales and everything else. But that high risk is going to be one factor that we're going to evaluate. But can you see how this is so much better than just having that, that hand grenade on the employment application where that applicant tells you about their criminal history, just being thrown in your lap, and you as either a hiring manager or as the HR professional looking at that and suddenly just deciding based on really no objective information whether this is really relevant or not. And so those are the, getting to this process does take some time. When I consult with a client to put together their policies and procedures around their evaluation of criminal history, and we build out this matrix, I've got a set of tools we use for that. And in fact, you can download those off our website. If you download my book, seven steps to bulletproof hiring, that's available on our website, it'll have how to use those tools and how to move through them. But when I do work with a client, I'm putting these together, most of the time we can put these matrices together for the positions in their organization in a day. Now, we're not doing it for every single position. So usually it's broad classes of jobs like admin, clerical positions in our organization that don't handle cash or have access to computer networks at an administrator level. Maybe that's 70% of your positions. And then we will look at people maybe in your warehouse, and maybe you divide your warehouse labor into two groups: those who are operating some sort of heavy equipment like a forklift or a truck, and those who don't. And that may cover all your warehouse employees except for management, who have a different kind of risk set. And so what I find in most organizations is that we end up with 4 or 5 of these matrices for broad categories of jobs, because this is just guidance. This isn't black and white circumstance. This is what we're saying. The company has evaluated this information. They've looked at these classes of jobs. They've looked at the controls that are in place in that specific company, and they've decided that this is high risk, medium risk, or low risk. That's the other thing I want to say, because what happens is whenever I talk about these at HR conferences, or I do a webinar and talk about these matrices that we've put together, everybody wants to say, well, hey, I'm an IT firm. We do managed services, and surely you've got a client there who's done that. And I say, yes, we do. That's what we work with several MSPs, and sure, we've put those together. And they'll say, well, just send me one of their matrices. And my answer is always, I wish I could, but I won't, because I don't want to give you the rope to hang yourself with, because every organization has different controls in place. They've got different standards. They serve different kinds of customers. And I wouldn't ever want to give somebody either a policy or a set of tools that worked for one organization and ask them just to apply that to their organization. That's in fact, when I do this as a consulting effort with a client, I certainly want HR in the room as we put this together, but I also want somebody from the C-suite in the room. Ideally, depending on the size of the organization, the president, CEO, CFO, somebody at that level who really has a risk management role for the organization. But then on the other end of the table, I want frontline supervisors, people who are really familiar with the role, who can really talk. It's amazing how many times I'm talking to these groups and we're talking about something, and HR will say, oh yeah, that role would never drive in the course of their job. And then the hiring manager says, well, actually they do. Or, yeah, they don't drive, but they operate forklifts, or they operate some other kind of heavy equipment, and we'd be concerned about that. So I want multiple perspectives around the table to make sure we evaluate the risk correctly, but also in the event that there ever is a disparate impact claim and how we put this information together is ever challenged, we can say, look, the C-suite was in the room, but people who really knew what was going on with that particular position were also here. So it takes time, but the most this has ever taken was 2 full days. And I didn't take the CEO's time for a whole 2 days, but it took us about 2 days for one of our larger clients that has just a whole bunch of different kinds of operation. Now, to really evaluate and understand somebody's criminal history, this is where it gets icky, okay? It gives a lot of employers, even seasoned HR professionals, liver quiver to have a conversation around somebody's criminal history. But you really, to stay on the right side of the EEOC's expectations, which is a whole nother webinar, but you really do need to be willing to have these conversations to really understand the context of what happened in someone's criminal history. Whatever story they tell you about their criminal history, always have them write it down. Because sometimes with some of these folks, we found that their story changes every time we talk to them. So have them write down more than just what the offense was. Our sample criminal history document gives them a whole bunch of space to tell us the context of what happened and to give us information about why the person who made those critical errors in judgment in the past is not who they are today. So let's look at the whole applicant and let's look at everything that's happened since then. The EEOC has a process that they want you to go through called individualized assessment. That is not in Title VII anywhere, and I have yet to find a Title VII case that says it's required. But it's not a bad idea, although some of the criteria they include in that in individualized assessment probably doesn't make a ton of sense, but we definitely want to document and tip our hats to the EOC, but also just have this opportunity to understand what the applicant actually did and what the context was and who they are now and how that may be different than who made that decision in the past. But then it's critically important to verify what they told you. We see it, the common example, we see it all the time, but the common example is the individual who is a registered sex offender. And they say, well, yes, I was 18 and I had a 16-year-old girlfriend and we had sexual relationships and the parent found out and they were angry and I got arrested for having sex with the person who was underage and now I'm a registered sex offender. I will tell you that in my 22 years of owning a background screening company, I've probably heard that story 2 or 3 times a year, at least from applicants. And we go, pull the court files and help our clients really understand what happened and get cases, copies of court documents. And I have yet for that to be the truth. Now, it certainly does happen. I've seen media articles of, stories about it. And I don't doubt that can happen on occasion. But I can tell you that it doesn't happen nearly as often as the registered sex offenders who we've talked to over the years have claimed it's happened. So you always want to get whatever they tell you. If you're inclined to believe them and to go ahead proceed with the hiring decision, let your background screening company pull court copies for you so you can see the details of what really happened and see if it lines up with what the applicant told you. And realize that if you're a second chance employer, there may be times where you need to make some sort of accommodation in order to help that employee be successful in your environment. If somebody has a recent criminal history, they may be under some sort of community supervision. Maybe they're on, probation, and they have to show up and speak to their probation officer on a regular basis. And probation offices are government offices. They work 9 to 5. And some probation officers and some community supervision offices are not what you would call cooperative. It seems at times that they have created systems that make it harder for individuals to succeed in probation. And so They may have to, at the very last minute, with very short notice, show up at the probation office. And so you need to plan for that. You need to understand that coming in, have that conversation. What's your relationship with your PO like? What are the current expectations for reporting, for showing up for drug testing? But I will tell you that a lot of our clients who are very active second chance employers, they will tell you our former offenders are, especially those on probation, are easier to manage because they've already got another set of eyes looking over their shoulder. And while the worst we can do to an employee is fire them, if these guys screw up and do something stupid, they can go back to jail. Their probation officer can put them back in jail. They have more pressure than your average employee to not do something stupid, to make good decisions, and that gives some employers extra comfort. But beyond having to show up for a probation office, you may have somebody who, maybe they've got pending charges and they have to wear an ankle bracelet, or maybe they've got a DWI conviction and they have to use an ignition interlock or something. They have to blow into a tube in order to start a car. And maybe if that's an outside salesperson who routinely takes individuals to lunch, you might not want that person in a position where they're having to blow into an interlock in front of a client just to start the car. So those are things you need to consider. What are the restrictions on this person's behavior and activity and conduct, and what might that mean for the role? But I think very often you can accommodate some of those things, but you just got to have that conversation again with the applicant to make sure that you're fair. Now, this is the first in a series, as I said, of webinars on topics. The next one is 7 steps to making bulletproof hiring decisions, and that's the one that is centered around the ebook, and you can get the ebook on our website for free. And you see the rest of them there. These are scheduled out through February, I think. So, and of course, they're HRCI and SHRM pre-approved for credit, and they will be the recordings are also on our website, so you can always go back and catch them later as well. Finally, Good Morning HR. It's my podcast, and I talk about all kinds of things related to HR on there. This is just a shameless plug for Good Morning HR. You can get it on Apple Podcasts, Stitcher, and we even put it out on YouTube. You can get it anywhere you get your podcast probably, or at goodmorninghr.com. We drop a new episode every Thursday morning, and they're interesting. It's just basically Mike Coffey asking dumb questions of really smart people, and I learn a little bit every week. And if you're HRCI or SHRM certified, each episode is worth half of a recertification credit. So you got that going for you too. So you can get, just as you drive to work, you can get recert credit. And jump that. Well, there we go. This is the slide for presentations at conferences, but you don't have to take Second Chance, because we will send you the slides at the conclusion of the webinar. And what we'll ask when we do that is just take a short survey telling me how I did. Please forgive me for not having a camera, because of course, as I said, today Zoom didn't like cameras, and I've got to figure out why. But other than that, let me answer any questions you've got. Let's see. Michelle asked, where does DWI fall? We have, it's a different category altogether on that matrix. And there's a section on that matrix, and I think it's called public safety offenses, and things like DWI would fall under there. And those are just broad categories. It doesn't really matter where, because you're going to look at that conduct, driving under the influence, as a specific behavior that somebody's engaged in the past, and tie that to the position. And so again, it may be high risk for one role. If they operate a motor vehicle or heavy equipment, that would make it a high risk. And so let's say the DWI was in the last 3 years or 5 years, maybe that'd make it high risk. That's going to be unique to your judgment and your organization. But if all they do is operate, drive a desk in your organization, sit behind a computer all day, then maybe even that DWI in the last 3 years is low risk. In fact, if I was depending on the specifics, I would probably argue or try to persuade you at least that you were that was a low risk offense for a lot of different kinds of positions. Were there any other questions I could answer for you? We're right at time. See here, I'm not seeing any other questions. My email is on the screen. You'll get an email from us later. Do watch for your spam folder later this afternoon or tomorrow morning, because sometimes our emails do go to spam. And again, you take the survey, and then if you complete the survey, you'll get the HRCI and SHRM recertification information if you need that for your certification. Not seeing any other questions, so please register for the future webinars. And if I can ever be of assistance to you, don't hesitate to reach out and give me a call. Thanks a lot. Oh, wait, do I have sample wording letting applicants know a criminal background record does not eliminate them from employment? I do, Beth. It's on our sample criminal history inquiry document, which is also on our website. Because I know and love you, Beth, I will email that to you as well. But everybody else can find it on our website. If you download the 7 Steps book, you'll see a sample criminal history inquiry document, and and it's linked inside of that document as well. Okay, looks like that's it for the day. I hope everybody has a great weekend, and we'll talk to you soon. Thank you all. Bye-bye.